Hey everyone, Brady, also known as the War Hamster in some corners of the internet, here with another episode of the Re-Federalist Report. Joining me today is my good friend, constitutional mentor, Douglas V Gibbs.
Glad to be here. Thanks for having me. Hello, everybody.
Always a pleasure. Today we're going to do the part two, a continuation of going through the Articles of Confederation, the original governing document of the United States of America. And last time we got through Articles 1 through 5. But before we jump in, for those who didn't see the first episode, Doug, can you give us a little bit of a quick overview and background for the Articles of Confederation?
The Articles of Confederation is basically the Constitution before the Constitution. It was the document used to create a government for us to operate under during war. Remember, it was written during wartime, during the American Revolution. And the importance of it was not just that we needed a governing document, but that the colonies, the new states, ever since the Declaration of Independence, have been trying to enlist the help of France. And France basically told them, we don't know if you're serious about this. We're not going to spend materials, personnel, and so forth to help you against Britain unless we know you're serious about this independence thing. It's one thing to write a Declaration of Independence. It's another thing to codify it into a governmental system, a union that shows that you are serious about moving forward. So the Articles of Confederation was also necessary to encourage France to join the war. It served as our governing document until the Constitution, but what it did is it did not create a republic like we have now. It created a confederacy, which is a loose-knit union in which the member states retain all power, except for a couple things, and the government, the central government, basically has almost no power. This caused issues when it came to certain decisions and debates over crossing state lines during the war. Early on, states, because they were using their militias, would also disagree with Congress on how to use their militias and sometimes refuse to send troops. And it was a central power during the war that really kind of brought it together once he figured out how to do it, and that was George Washington. So there's the lesson there is you do need a central controlling focus or government or governance system or person or something in certain situations. And that's what they understood when it came to the Constitution later, is giving all the power to the states would have doomed the Union in the long run. There needed to be a central government that could handle issues that are good for the Union. As we go through the Articles of Confederation, here's what you're going to notice if you are familiar with the Constitution. There's a lot of similar language. When they wrote the Constitution, a lot of the language they used came from the Articles of Confederation. And a lot of it is better, I think, better explained in the Articles of Confederation. But with that said, I hand it back to Warhamster here.
Yeah, you said something interesting. France wanted to make sure that we were serious about this. And what this was the ability of a people to govern themselves, self-determination, without having, a central power or a king looking over you, or handing down all the decision making. Can people rule themselves? It was the first time in a long time that any free people, had tried this experiment, and France definitely had a vested interest in seeing it succeed, because the founding fathers didn't just sit down in 1776 and come up with this idea. They were borrowing from the works of a lot of great thinkers, from the entire Renaissance period and the Reformation, the Renaissance, all this era of enlightenment. And there's, we could make a who's who laundry list of great thinkers they borrowed this from, but a lot of them were French. And so France absolutely knew what we were doing.
Like Montesquieu.
Montesquieu, for sure. I guess he's used to be more of a favorite than he is today, now that I've learned a little bit more. But John Locke was a great writer at the time. They borrowed a lot of his ideas. And of course, we have Vattel, whose Law of Nations, served as basically a guidebook for a lot of these, articles in the Articles of Confederation.
Mm-hmm.
So with no further ado, we are going to jump into Article 6. And it is a long one. So we're going to do it piece by piece. Okay. Article 6. No state without the consent of the United States, in Congress assembled, important word there, assembled, shall send any embassy to or receive embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state. Stop right there. Basically, what they're saying is the whole purpose of forming this central government is to handle foreign affairs. And of course, that language you'll find in the Constitution.
Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation. And then later on, near the end, then no state shall enter into any agreement or compact with another state or with a foreign power or engage in war unless actually invaded. And this is key because, once again, we're trying to recognize a union here. And the states and former colonies are used to handling everything on their own. They're not used to being in a union. They were the only association they really had with each other before was the fact that they were all English. But they really did operate as their own countries. And a union doesn't do too well if you have rogue states doing whatever they want rather than working with the union. So while we didn't want a nation that's governed in an authoritarian manner with an overpowerful centralized government, at the same time, we couldn't go the opposite extreme. And even with the Articles of Confederation, as loose-knit this union was, we wanted to make sure that the states weren't running off and doing other things. And this was actually key, too, because there were a lot of countries in Europe that were wanting to pit the states against each other. And perhaps, get trade with certain states to go in their favor, maybe even take a few states from the Union. So this was also a protection against European countries that wanted to play that game of pitting the states against each other and gaining favor with certain states and so on and so forth.
Yeah, I wanted to point out the part of this that says no state without the consent of the United States in Congress assembled. Mm-hmm. So that language is going to be repeated throughout the document, and right. It's important. We didn't have a sitting government. The only time the central government could do anything is on the rare occasions, and it was rare, when Congress was actually in assembly. We'll see that language pop up again here quite a bit. And they didn't want a permanent government. They figured, we'll meet once a year, and that should be enough to handle, the international affairs that we need. So continuing, and this language would be familiar. Nor shall any person holding any office, profit or trust under the United States or any of them, except of any present emolument, office, or title of any kind whatever, from any king, prince, or foreign state. Nor shall the United States in Congress assembled, again, or any of them grant any title of nobility. So the emoluments is pretty self-explanatory, and we still have that, obviously everyone decided to all of a sudden become a constitutionalist and learn the emoluments clause when Trump was in office the first time.
Yeah.
But it's the titles of nobility. And that was, they were opposed to that from day one. That would make its way into the U.S., into the Constitution, and would also show up in our famous missing 13th Amendment. So this was a big deal to the founding generation, as the titles of nobility.
And Article 1, Section 10 of the Constitution reads almost exactly the same. And when we talk about nobility and all, title of nobility and all this goes all the way back to Thomas Jefferson's words of the Declaration of Independence: all men are created equal. We are not privileged because of our birth or because of our connections. They're not supposed to be anyway. Yeah, I know that they today it seems like our system, while may not be officially that, sure tries to imitate it.
Your Honor.
Yeah.
That one drives me nuts. I mean, basically the legal system has put itself above the law in many ways.
It's funny because I have never used the words Your Honor in court. I would always say judge and last name when addressing them, and so far I haven't been called out for it.
I fortunately haven't had to appear before many judges, so I haven't had the opportunity to put that to the test myself. But
I've had about half a dozen stories for another time.
Yeah. And one that I can't share, but we'll get there. All right, moving on. No two or more states shall enter into any treaty, confederation, or alliance, whatever, between them without the consent of the United States, in Congress assembled, specifying accurately the purposes for which the same is to be entered into and how long it shall continue.
So we saw language like this earlier, but notice here, it's really saying if you are going to do this, it's going to be temporary.
Yeah, and we're pushing the limits on this these days. I mean, we saw during COVID, I was in California, so were you, and we saw Gavin Newsom making unusual deals like with China.
Right.
Is it going beyond normal regular commerce, or they're entering into those kind of treaties or alliances? I wouldn't call it an alliance, but we definitely have seen states push the limits on this language. And it's still, we have, obviously, we got the exact same language in the Constitution. They borrowed this.
Once again, Article 1, Section 10, which I mentioned earlier, and it shows up twice. And, right now, just off the top of my head, you have this alliance of states when it comes to the national popular vote movement, which they have joined into a compact that if there's enough states that equal 270 electoral votes or more, that whoever wins the popular vote will automatically get those electoral votes from those states. Of course, if they'd done this and that, and in the last election, 520 electoral votes would have gone to Trump. That's beside the point. The other one is this governors and states getting together for resistance against Trump, and they have a name for it. It's a governors supporting democracy, and I think they have another name also. But anyway. It is an official. It has a website. It's an official organization. It's an official alliance or compact. And once again, that violates the Constitution. Now, this language you're seeing here, though, as opposed to language that was a couple of paragraphs up, is more specific about with other countries or in foreign affairs. The first bit of language, which we talked about earlier, was more about creating compacts that would allow the states to form a group to team up on other states or something like that. So that's why it's there twice. The first one is regarding within. This one here is outside, dealing with the rest of the world. The states are not to deal with the rest of the world. That is the job of the union.
Yeah, and that's really the point I was going to make too. And we'll see this again in the next paragraph. But this part right here really speaks to what was the purpose of a federal government, a centralized power. And it really was simple. Is the enumerated powers is to handle foreign affairs, treaties, what have you, war, defense, and basically to handle interstate commerce disputes. And that's really all the government was supposed to do. Everything else the states could handle themselves because they had been. So continuing on, no state shall lay any imposts or duties which may interfere with any stipulations in treaties entered into by the United States in Congress assembled with any king, prince, state in pursuance of any treaties already proposed by Congress to the courts of France and Spain. Basically, what they're saying is no, the states do not get to do their international negotiations, period.
Right, and you got to understand something. When the Founding Fathers sat down and write this document or the Constitution, understand they had really no place to glean this language from, because there had never really been a system in the past where it was states in a union who were going to retain all of their internal issues, but yet form a government to handle external issues. This was language they came up with without really the aid of other documents. This is the first time we're seeing a union of states who are in a voluntary agreement to be a union and have a central government operating. It's first time in history in this manner. And so the language is very interesting and it's very specific, but it's specific not because they gleaned it from somewhere, but because they were watching from a point of view of experience. These colonies as a group, found that it worked better when they worked together as a union. And they also recognized, and I hate to say it this way, but when you do have some states that aren't cooperating, like, Rhode Island, then things don't go as well as you want. So there were certain things that had to make sure none of the states could sabotage, and treaties being a part of it. They left the central government handle the stuff for the union.
Yeah, you just can't have 13 different, ambassadors to Spain or France, as mentioned in
Right,
the paragraph. Yeah, you needed one unified opinion. You also didn't want these foreign powers, basically cutting a deal with, say, South Carolina,
right.
beachhead, because we didn't want them. This is supposed to be, we're supposed to be independent and free of these Central European powers.
And once again, there were Central European powers that wanted to do that. They wanted to deal with only certain states and pit them against each other and create that chaos. And this was kind of a opening salvo to avoid that.
No, sure. Spain was right there in Florida, creating colonies. France was a couple
Sure.
states over. All right, continuing. I like this part. No vessels of war shall be kept up in time of peace by any state, except such number only as shall be deemed necessary by the United States, in Congress assembled, for the defense of such state or its trade. That's talking about the Navy. Now, this would be let's go read the next sentence because it goes into the standing army. Nor shall any body of forces be kept up by any state in time of peace, except such number only as, in the judgment of the United States, in Congress assembled, shall be deemed requisite to garrison the forts necessary for the defense of such state. They're really talking about not having a standing army. The first sentence was more relating to the Navy. And as you've pointed out, when we get to the Constitution, they modified this a little bit and allowed for a standing Navy. Now, they did that because they realized that trade was the lifeblood of a country at that point in time. And as all trade was, almost all trade was done over by the sea. But they had a lot of fear of a standing army. And now, obviously, that's because they've been living under, British rule, which had, a standing army, an occupying force.
They also understood that, and Jefferson actually during his presidency, despite the fact that he was always called a war hawk by the Federalist Party, which really wasn't true, Jefferson had the attitude that kind of matched this, which is this: when we need the military, then we can bring it up. Otherwise, we keep it as small as possible for the basic purposes of defense, just enough to defend. If we're gonna, you don't want to go around having this huge force. When he became president, because there was no war, he reduced the size of the military to almost non-existence. Then when it's time for war, then you recruit, you build, you create what you got to create to handle whatever it is. The attitude was it was an unnecessary expense, and it was an unnecessary group of people that could be used against the people as a standing army. So therefore, you keep it as small as possible when it's not needed.
Yeah, this next part really addresses that too. It says, but every state shall always keep up a well-regulated and disciplined militia. Love that language. Sufficiently armed and accoutered, and shall provide and constantly have ready to use in public stores a due number of field pieces and tents, and a proper quantity of arms, ammunition, and camp equipage.
Well, you talk about specific.
Mm-hmm.
And did you pick up on some of the language that, I don't know, might show up in, Second Amendment?
Mm-hmm. Well, it's it's interesting because the previous sentence they talked about a standing army, and then they said, but you also have a well-regulated militia. They were delineating between the two.
And notice it says well-regulated and disciplined, which ties into what regulated means. It's in good order. It's ready to go. It's well-equipped, so on and so forth.
Yeah, and again, a standing army was a central government authority, was under the power of D.C., or wasn't D.C. at the time, and a well-regulated militia is under the control of the states. They were making it crystal clear that they feared a central power. They did not want centralized authority.
And in Article 1, Section 8, and I refer to this often in my classes because when the Second Amendment was written, the groundwork for it had already existed here and in the Constitution. So when I talk about well-regulated militia, when I talk about the Second Amendment in class, and I explain what it means is a militia that's in proper order, in good order. How do you put it in good order? How do you make sure it's equipped in? Well, that right there, the United States will then provide for it, the proper number of field pieces, tents, and so on and so forth. Here's what it says in the Constitution. just for the purpose of being able to make the comparison. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Now, here's the thing that created the controversy. The language you'll notice is here that wasn't in the Articles of Confederation was that the federal government could call the militia up to serve the federal government. Here, they did not allow for that. The militias only belong to the states into conversation. But in the Constitution, they belong to the states, they primarily belong to the states, but the federal government had the option to bring them up. Where did they get this idea? Well, the militias were a key component in the Revolutionary War under the service of the Union. But at the same time, when the militias were not called up in the service of the federal government or the central government, they were operating under the states. The states would often not cooperate on how they needed to be deployed. And so they realized that if ever American Revolution situation came up again, and while you will have your regular army, the militias are also going to participate. You can't have the states sending the militia off wherever they want. You've got to have a central power saying, no, we've called them up to serve us. They're going to operate the way we want them to operate. So that's why there's a difference. It's a lesson from the Revolutionary War.
Very good. All right, continuing. It's a long one. Stop me wherever you want me to.
Okay.
No state shall engage in any war without the consent of the United States in Congress assembled. Seems self-explanatory. Unless such state be actually invaded by enemies, or shall have received certain advice of a resolution being formed by some nation of Indians to invade such a state. And the danger is so imminent as to not admit of a delay till the United States in Congress assembled can be consulted.
All right, yeah, that right there, and that is basically the final half of the final paragraph of Article 1, Section 10. And once again, what this does is say, you are not, as individual states now, because we're in a union, you're not going to wage war on your own. You're having issues with foreign powers or foreign sovereignties, which would be the Indian nations, the tribes. You've got to go through the central system. I tell people when it came to the Articles of Confederation, while the states retained all of their internal powers, the powers they did give to the central government was the ability to declare war and wage war, and that's what this ties into. The states don't have that authority to just go running off and starting a conflict on behalf of the United States on their own. There has to be an agreement. It has to be a unified force. Unless, of course, you're being invaded or you know that you're going to be invaded, then you have a right to defend yourself. Now, and this is also key in today's immigration policy. Same kind of thing. It's up to the federal government to protect the states. But if you're in the middle of getting invaded, if you're in the middle of being attacked, you've got the authority to defend yourself.
Well, yeah, you can't wait. You can't wait months for Congress to assemble. I mean, it took a long time to get Congress assembled back then. Everyone had to travel from long days away. And if you're out in one of the frontier states and you know what is hitting the fan, yeah, defend yourself. It gave them a lot of outs. Who determines that the danger is so imminent? Well, that's a little vague. But at the end of the day, the insinuation is there. Yeah, you can protect yourself.
Yeah, well, and they're saying you don't even have to be invaded. You just have to think you're going to be invaded, and you can defend yourself.
Yeah, it's vague enough to allow quite a bit of wiggle room.
And you said something interesting. You're talking about how it would take weeks or months for Congress to assemble and get their job done, which kind of reminds me of my favorite Bible verse. For God so loved the world, He didn't send a committee. All right.
All right. That's good, Doug. Nor shall any state grant commissions to any ships or vessels of war, nor letters of marque or reprisal, except it be after a declaration of war by the United States in Congress assembled, and then only against the kingdom or state and the subjects thereof, against which war has been so declared. And under such regulations as shall be established by the United States in Congress assembled, unless such state be infested by pirates.
I like that language, infested by pirates.
In which case, and that was a problem back then.
Oh, yeah, absolutely. Matter of fact, I'm actually one of the books I want to write next year is Pirates and the Founding Fathers, or Early America, or something like that. I think it'll be fun. Anyway, go ahead.
Well, that's one of the things I always say is, what's the difference between a pirate and a privateer? It's a piece of paper.
Yeah, true enough.
Finishing this, it says, in which case vessels of war may be fitted out for that occasion and kept so long as the danger shall continue, or until the United States and Congress assembled shall determine otherwise.
And again, we're getting back to when it comes to the defense of the Union, that's up to the Union. However, this language differs from the Constitution. Here, it grants an exception.
When they do that, because in the paragraph above, where it says no vessels of war may be kept in time of peace, we didn't have a U.S. Navy
per se.
It was up for the states to defend their own trade routes. Now that would change under the Constitution, because they recognized that you probably do need a centralized Navy or a controlled Navy. And
right.
But again,
hence the reason why in Article 1, Section 8, there's a 2-year funding option for the Army. Every 2 years it has to be refunded, but the Navy, it's like, and you shall have a Navy. There's no limitations. It must be. And but at the same time, they did not want, once again, the states overpowering the Union, doing things that the Union should be doing. We didn't want confusion when it came to our foreign adversaries or trade partners. We're operating as a Union. Therefore, when it comes to vessels and all of that, they're going to fall under the Union, under the central government, under the United States.
Yeah, and that brings up a historical point. We followed that pretty well throughout our history until World War II. We built up, like for World War I, we were not prepared to go to war. Germans had better technology. We didn't have a standing army. We had to put that together pretty quickly. Right. And then went off and fought World War I. When it ended in the 1920s, we downsized the military. And coincidentally,
just like Jefferson did. It was the same kind of thinking.
Well, so one of the things that would happen is after World War II, we did not get out of the Great Depression until we went into wartime military spending. We nationalized the entire economy, and we built up this huge war machine. We changed factories to producing, weapons of war and arms, etc. Well, we would have fallen right back into depression had we downsized the military at that point in time. So what they did instead is they kept the military huge, and it's been a rubber stamp. That 2-year renewal has been a rubber stamp from Congress ever since. We get more into the geopolitical economic reasons for doing that, but that was basically the war machine decided it wasn't going to downsize itself, and they basically shifted our production to consumer goods, created we had the Bretton Woods dollar regime started. We had the Marshall Plan, and we basically lent money to all these rebuilding countries all over, that suffered from World War II, and turned them into, consumers. We basically lent them the money to pay our war machine as it was converting. The Army's never downsized from World War II, and I don't know that it will, and it probably should.
And as for that, every 2 years funding the military, that's what your National Defense Authorization Act, NDAA, is, if you ever wondered. As I know, every couple of years, the NDAA winds up in the news and conspiracy theories and everything else, and they're, oh my gosh, they're doing this and do it. Well, that's true. What part of our problem with our Congress, they shove a lot of stuff into things that shouldn't be there. It should, when they should stand on their own, standalones. But that's what the NDAA is that every 2 years, the military getting funded. Once again, the Navy doesn't fall under that. It's automatically funded. There's no approval needed. But when it comes to the rest of the armed forces, approval is needed according to Article 1, Section 8 of the Constitution. And this kind of reminds us of the different situation there. And that matter of fact, when we get into our next paragraph, it's also going to remind us that we have states that need to defend themselves, but a country that needs to take care of business militarily. And at the point here, they hadn't worked it out yet.
Yeah, and that's why Eisenhower called it the military-industrial complex, because it was not just about the use of force. It was, basically had to support this whole defense machine.
Leviathan.
It's a good word for it. Article 7. Related, when land forces are raised by any state for the common defense, all officers of or under the rank of colonel shall be appointed by the legislature of each state respectively by whom such forces shall be raised, or in such manner as such state shall direct, and all vacancies shall be filled up by the state which first made appointment.
And this is not just the militias. Now, remember, this is the army too. The states controlled segments of the army. Anyway, continue. Go ahead.
This language didn't quite make it into the Constitution.
No. In fact, the language in the Constitution says that the president shall commission all officers.
Yeah, and that's actually, we talked about that a bit when we were talking about the 14th Amendment. What is it? Is an officer appointed, commissioned, what have you? And is the president such an officer? And the answer was, of course, no, because he's elected.
Right.
Article 8. All charges of war and all other expenses that shall be incurred for the common defense or general welfare, love that word, sarcastically, and allowed by the United States and Congress assembled, shall be defrayed out of a common treasury, which shall be supplied by the several states, this is important here, in proportion to the value of all land within each state, granted to or surveyed for any person, as such land and the buildings and improvement thereon shall be estimated according to such mode as the United States and Congress assembled shall from time to time direct and appoint. What are they saying there, Doug?
Well, what we're saying is, first of all, there's going to be a single treasury. It's going to be contributed by the states, and the states, their contribution is going to depend on their size. Now, here it's geographical. Later on, it's going to become more about population.
Exactly. That's the huge distinction we see. And this goes back to the compromise between the Virginia plan and the New Jersey plan. Should it be population-based or territorial-based? But in this case, they basically said we're going to estimate the actual monetary value of the property in your state, and that's how much you'll pay.
Well, early on, value was not as important as was how much. You can even see that when it came to the way they did property taxes back then. It wasn't based on the value of the property. It was based on if it had a structure and the number of rooms the structure had. That's how the property tax was determined, not based on value. And so if you had a lot of land, but there was no structures on it, you really didn't pay much in taxes because it wasn't being used for anything. For the most part, it was just property. It was big farm, whatever. And they wanted to keep the producers from having to pay heavy taxes. But if you've got a lot of buildings on this property and you've got an industry going on, well, then now the taxation would go up. And that's the reason why, and this is just a little bit of trivia, bathrooms early on were called water closets. And the reason why is because if it was a room, it would cause the taxes to go up. So it couldn't be a room, it had to be a closet. So it was a water closet, and that avoided you from having to pay extra taxes having a bathroom.
Yeah, we in the Constitution, we talked about the large states versus the small. In this case, it's more the wealthy states versus
geographical. Yeah,
they're supporting the other. And this is still controversial today. I mean, you see things like use taxes and stuff like that. But the whole idea of property tax, one of the arguments is that if you're not using the property, I shouldn't have to pay taxes on it. But what happens is in these towns and rural towns, stuff like that, someone will buy up a bunch of the land and not use it. And that therefore driving up the property values from a tax purpose of the land that is in use. Right. And this is an ongoing controversy. It has not been solved.
Yeah, and understand that this document was presented by Congress a full decade before the Constitution was written. So they had about a decade to learn a lot of these things where you see the changes. And a decade may not seem like a long time to us today, but that is almost an age back then. And they did learn a lot along the way, not only from the war, but also from that time period after the end of the war, which was about a 4-year period from 1783 to 1787. And so, like I said, you'll see a lot of the same use of some of this language, but you also see a lot of language not appearing in the Constitution for good reason.
The first sentence, they talk about the only expenses they're going to be taxed for is for the expenses that were being incurred for the common defense. And they say,
and general welfare. That's the general condition of all's well in the country.
Yeah, but who determines that? And that's the open door for Congress to create the welfare, the general welfare clause. It allows Congress to basically spend on anything they see fit.
Yeah, but notice though, if this is taken from the way it was originally meant, your taxes were to go to only the things that were for the external use. Your states are going to collect taxes for the internal stuff. It has to be the external stuff, common defense and general welfare. In other words, the things that make sure the union is preserved is essentially what they also mean there by general welfare. And in the Constitution, once again, general welfare appears twice, once in the preamble, once in Article 1, Section 8. And Jefferson and Madison a number of times tried to explain what was originally meant by general welfare, referring back to this language here more so than what the Hamiltonians, Alexander Hamilton followers, had really created it to mean, to the point where, and I think one of the most important documents for people to read, and I would encourage you to read it if you want to understand the general welfare clause, to the point that in 1817, in a veto of a public works bill called the Bonus Bill, James Madison, in his veto, explains, this is not what we meant by general welfare. Here's what we meant. You guys have it wrong. Here's what we meant. He explains it. He lays it out. And yet still today, even though it's been laid out by the father of the Constitution, because of those seeking power, whatever, we still get it wrong.
Yeah, and when he says by those seeking power, you're talking about the business interests that try to get as close to the seats of government as possible because they want the government contracts. And the day this was written, what they called internal improvements were they wanted to build canals. In the 1800s, it would become railroads. And an awful lot of people got very wealthy from their government contracts. You may have heard of them, called the robber barons. It didn't work out too well. This is the American system that Hamilton was so proud of.
And when someone says robber barons, people use that term inaccurately often. We don't mean companies have done well, the executives have done well, and they're very wealthy because of the hard work of what they've done. It's when government and industry starts playing this mercantilistic game, playing favorites, playing footsies with each other in a sense. That's when you get the robber barons, where they're taking advantage of federal influence and they're using their own power to influence government.
Yeah, it's not that we're against canals or railroads. What we're against is the inevitable corruption that comes from the public-private partnership, and it's inevitable. You're always going to find people, they realize how much money is at stake when you're going to get paid from the public coffers, and you're going to put politicians in place that are going to send business your direction or vote to spend on more expansionist spending. The railroads are the best example of this ever. To build the Intercontinental Railroad that the government funded, it zigzags all throughout the Midwest because mayors of those towns would bribe the railroad company because we want a railroad in our town. It was corrupt as all heck. I mean, Abraham Lincoln was a very corrupt railroad lawyer for this purpose. But the government-funded Intercontinental Railroad took twice as long to build and went well over 2 times the estimated cost. The private Transcontinental Railroad, which went from somewhere like Minneapolis to Seattle, was built in half the time at half the cost because it didn't have that government corruption.
And it wasn't so zigzagged either.
Yeah. And the shortest distance between 2 points is a straight line. They figured that out. But it really, to me, it's one of the best examples of how the government really doesn't do anything well besides collect taxes and wage war. Everything else should probably be left to private hands. It'll be more efficient. It'll be done correctly and on time because people have stake. They have a stake in the game. Continuing, the taxes for paying that proportion shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled.
The states created the government. The government didn't create the states. And therefore, to pay for that government, it's going to be the states deciding how to do it. And this would transfer over to the federal government with the Constitution, in which the taxation, which is laid out in Article 1, Section 2, would be based on the population of the states. But the states were paying the income tax. There was no direct tax from the people. The taxes paid was by the legislatures of the states. Now, and what would happen under the Constitution until the 16th Amendment is the states would then say, well, you know what? We saw your budget. We're not paying for this, this, and this. Fix it or you don't get anything from us. The states had control over the federal funding because they had control over the money being put into it. And that kind of blossomed out of this right here.
Well, and that's basically was taken away in 1913 by the 16th and 17th Amendment. Right. And we've seen the results of that, a bloated leviathan of a government.
Right.
And I think it's fair to say it does not work. Article 9. All right, deep breath. This is a long sentence. The United States, in Congress assembled, shall have the sole and exclusive right and power of determining on peace and war, except in the cases mentioned in the 6th article, of sending and receiving ambassadors, entering into treaties and alliances, provided that no treaty of commerce shall be made whereby the legislative power of the respective states shall be restrained from imposing such imposts and duties on foreigners as if their own people are subjected to, or from prohibiting the exportation or importation of any species of goods or commodities whatsoever, of establishing rules for deciding in all cases what captures on land or water shall be legal, and in what manner prizes taken by land or naval forces in the service of the United States shall be divided or appropriated, of granting letters of marque and reprisal in times of peace, appointing courts for the trial of piracies and felonies committed to the high seas, and establishing courts for receiving and determining finally appeals in all cases of captures, provided that no member of Congress shall be appointed a judge in any of said courts. There's a lot to unpack there, but big picture is this is under the authority of the federal government.
The central government. And what would a lot of this language would wind up in Article 2 or Article 1, Section 8 later in the Constitution. But this is basically saying, once again, we are creating this government not to control the states, but to handle things that the states individually shouldn't be. And like you said earlier, so you're not sending 13 ambassadors or in today's case, 50 ambassadors to a country to negotiate a treaty. You have a single system that's representing the union to the rest of the world.
Yeah, that's a pretty good summary. I don't think we need to break this down piece by piece. All right, continuing. Article 6. Sorry, it's Article 9. Got to remember how to read my Roman numerals. The United States in Congress assembled shall also be the last resort on appeal in all disputes and differences now subsisting, or that hereafter may arise between two or more states concerning boundary, jurisdiction, or any other cause whatever.
Stop right there just for a second. Yeah. It's funny because I talk about the Commerce Clause in the Constitution, for example. And today's belief is if it crosses state lines, it's automatically a federal authority. And what they meant originally, if you really go back to Madison's notes and all that, was commerce between the states was to be left alone by the federal government. It was none of the federal government's business unless a dispute arose. And that's what this is basically saying. The central government will act as a mediator or a referee in case there's disputes. Otherwise, the states are going to be left alone.
Yeah, and this really, we start talking about Article 3. And this is one of my pet peeves is the Constitution basically in Article 3 said basically the same thing this is saying, that the federal courts exist to handle interstate disputes. If it's inside a state, the state courts handle it. Well, that lasted all of 2 years under the Constitution with the Judiciary Act of 1789, where they basically allowed the federal courts to stick their noses into state business. It's been a problem ever since. The language is clear what the intent was, both in these Articles of Confederation and in the Constitution, but Congress took all of 2 years to just completely rewrite that. It was something that absolutely needed a constitutional amendment, but instead was passed by a congressional act. It should be invalid, but yeah.
And the fear came from experience watching and dealing with these monarchies from Europe. What would happen ultimately is the courts would become a rubber stamp for the king. And the legislature would just stop mattering, and half of that legislature back then being the voice of the people, the House of Commons. And so they feared that the judiciary would be used by the president or by the system to work around and overpower we the people in our representation. And that's why they put such limitations on the judiciary. When the Constitution was originally written, the judicial branch was the weakest of the three branches on purpose. And this is an example of the language that they were using back then to guard against a runaway judiciary.
And we see that happening. Like right now, it's happening in Brazil. You've got a dictatorial judicial system that is basically running the country.
Right.
Which authority shall always be exercised in the manner following. Continuing. Whenever the legislative or executive authority or lawful agent of any state in controversy with another shall present a petition to Congress, stating the matter in question and praying for a hearing, love that language, notice thereof shall be given by order of Congress to the legislative authority of the other state in controversy, and a day assigned for the appearance of the parties by their lawful agents, who shall then be directed to appoint, by joint consent, commissioners or judges to constitute a court for hearing and determining the matter in question.
Now, notice something here. When there was a dispute between the states, the ultimate decider was not a Supreme Court; it was Congress, and you were able to petition the government for a redress of grievances. In this case, petition Congress. Back then, when Congress went into session, the first part of their session, the first thing they did is they went through all of the petitions. That is something that has disappeared, not because of the Constitution not allowing for it. They did, but because over the time when during the 1800s, there were so many petitions about the abolition of slavery that the Congress didn't have time to go through all the petitions anymore. So they just said, we're not doing petitions anymore. And petitions never came back. This is very important because, once again, this is showing A, the people being able to petition, having a voice, and B, the courts were subservient to the Congress.
What's also really interesting is it talks about, well, we're going to appoint by joint consent commissioners or judges for each issue that comes up. That implies we do not have permanent judges or, sitting courts.
Right.
Continuing, but if they cannot agree, Congress shall name 3 persons out of each of the United States, and from the list of such persons, each party shall alternatively strike out 1, the petitioners beginning until the number shall be reduced to 13. And for that number, not less than 7, nor more than 9 names as Congress shall direct, shall in the presence of Congress be drawn out by a lot. And the persons whose names shall be so drawn, or any 5 of them, shall be commissioners or judges to hear and finally determine the controversy. So always, as a major part of the judges who shall hear the case, shall agree in the determination. Stop right there.
Notice that the choosing of the judges for these situations almost sounded like today's version of choosing jurors.
Yeah, it really does. And it's interesting, you would the states would put they nominate here are the people that we think can, judge fairly, or fill this role in a reasonable manner, and then they go in, they get picked out by lot, and theoretically you get a fair and unbiased jury of your peers. And if either party shall neglect to attend at the day appointed, without showing reasons which Congress shall judge sufficient, or being present shall refuse to strike, the Congress shall proceed to nominate 3 persons out of each state, and the Secretary of Congress shall strike in behalf of such party absent or refusing. Just more language about how to create these tribunals.
Show up or you're not a part of it.
Unless you got a good excuse. They gave you the out. And the judgment and sentences of the court to be appointed in the manner before prescribed shall be final and conclusive. And if any of the parties shall refuse to submit to the authority of such court, or to appear or defend their claim or cause, the court shall nevertheless proceed to pronounce sentence or judgment, which shall in like manner be final and decisive. It says whatever they decide these tribunals will be, their word will be law.
That type of language, though, is what makes the judges feel like they're the final arbiters of things. They are the final arbiters, maybe in certain criminal cases and so on and so forth, sentencing, but not in, say, the reading of the Constitution. But anyway, continue.
Well, it goes back to titles of nobility, Your Honor.
Mm-hmm. Yeah.
The judgment or sentence and other proceedings being in either case transmitted to Congress and lodged among the acts of Congress for the security of the parties concerned. Provided that every commissioner, before he sits in judgment, shall take an oath to be administered by one of the judges of the Supreme or Superior Court of the state where the cause shall be tried. And here's in quotes. well, and to truly hear and determine the matter in question according to the best of his judgment without favor, affection, or hope of reward. Provided also that no state shall be deprived of territory for the benefit of the United States. That last sentence is a big one. We recently on my channel, I had our good friend Alan Myers on to do his, talk about federal land grab.
Mm-hmm.
And, this was a big deal. The state's territory was sovereign. No court could determine otherwise that the government did not have the power to seize territory.
Of course, in Article 5, Amendment 5, it does give the option for public use, but it has to be the language uses for just compensation. In other words, if government is to use private properties to seize it, it must be with just compensation. And I've already talked about this in my classes. What is just compensation? What is considered just by the owner? When it comes to the states, the same thing. When Article 1, Section 8, how can the federal government gain property from the states? It must be purchased it must be purchased with the approval of the state legislature for the purpose of needful buildings. In other words, what happened here is they went from no state shall be deprived of any territory by the United States to, well, okay, we realize the federal government may need property, so we're going to allow for it, but it's going to be difficult. It must be paid a just compensation, eminent domain, to the owner if it's private, and if it's the state that owns it, must be approved by the state legislature, must be paid for, and it must be for the purpose of needful buildings. In other words, you can't have property for the sake of having property. And needful buildings being buildings that fall under the authorities given by the Constitution.
Which is why I've never been a huge fan of Teddy Roosevelt.
Right.
A lot of people on the conservative side think Teddy was this great president, but he was one of the more unconstitutional ones we ever saw. And most of it's because he seized a lot of federal land.
Well, he saw himself as the first progressive president.
He ran as the candidate for the Progressive Party.
Right
in the middle of the Progressive era, which gave us some of the worst legislation in the United States history. Mm-hmm. The other issue here was, that they were emphasizing is at the time, and even ongoing today, there were territorial disputes between the states, particularly Maryland and Virginia. Mm-hmm. And if you look at a map, how Maryland is carved up, it's the surveyor must have been drinking. I don't know how they came up with those borders, but there's been a lot of border disputes, and obviously we didn't have technology back then, so there was not as precise of a science as it is today. And there were, that was a big issue. This pond is in our state, not yours, and that they obviously were very much aware of that issue and wanted to make sure the court could not supersede that state authority. All right, we're coming up on about 53 minutes right now, Doug. So let's go through the next paragraph and to give this a wrap.
All right.
All controversies concerning the private right of soil claimed under different grants of two or more states, that's exactly what I was just saying, whose jurisdictions, as they may respect such lands, and the states which pass such grants are adjusted, the said grants, or either of them, being at the same time claimed to have originated antecedent to such settlement of jurisdiction, long sentences, shall on the petition of either party to the Congress of the United States be finally determined as near as may be in the same manner as is before prescribed for deciding disputes respecting territorial jurisdiction between different states.
Notice that it does not say the central government will be the commander or the authoritarian decider. The government, the central government here and in the Constitution, was designed to act as a mediator. And if you've ever been a mediation when it comes to in a court of law, and there's the mediator kind of does this, running between the rooms kind of thing. Well, this person says, that person says, the court's not dictating, the court is mediating. And that's what it's saying here. If the central government's going to act as a mediator, it really comes down to the states working it out with the central government acting as a mediator.
Very good. Obviously, that's a really important issue, and I like the language right here. Be finally determined as near as may be. So they're acknowledging the imprecision of, the ability to survey land at the time. It was imperfect, and they were allowing for that. But it's interesting that once again that Congress has the final say in these things.
Yeah, it's almost like the Heisenberg uncertainty principle suddenly existing in this rudimentary document. Those that are not familiar, the Heisenberg uncertainty principle, it basically says that nothing is perfect. Ultimately, that's what it means.
Which is probably true. Of course, you ask the courts today, they probably see themselves a little bit more perfect than they probably ought to.
Well, yeah, after all, they are, Your Honor.
We got through a good chunk there, Doug. And again, it shows what were the issues that were so important to them.
Right.
Obviously, it was the common defense was number one. But, how are we going to actually handle disputes? What is the purpose of this general government that we are forming? What are the limitations?
And generally, it's like we need a government of some kind, but we're scared to death of it having too many central powers. We're going to do everything we can to limit it and keep it in its role.
It's almost like there's something called the enumeration doctrine.
Something like that. And once again, a lot of what became the Constitution developed from this exercise. And I'm going to call it an exercise. That's essentially what it was. It was a document written during wartime necessary to create a union, a country's government, but yet they were fearful of it having any power per se. So they did everything they could to limit it. Once it was established, they realized they had gone too far to the Confederation point of view and not close enough to the national point of view, but we still don't want a national government. So we got to find something that's in between, a compromise, something that creates a balance. And that's where they came up with the idea of a federal republic with a federal government.
Very good. We're going to have a part 3 and maybe a part 4. To get through it.
And thing is, and let me say this real quick. We spend a lot of time studying our Constitution and maybe even the Declaration of Independence, but there are so much more to get the full context. There's so much more we need to study. Articles of Confederation being a very large part of that. So for those of you who are going through this with us, thank you, because and I hope that this is opening your world a little bit when it comes to your understanding of history, why our Constitution is worded the way it is, and why some of the ways of operating back then were the way they did it.
Yeah, they understood some of the pitfalls of having too big of a central government. They understood the pitfalls of having too loose of a central government. And again, this is always an experiment. And when they realized that, oops, we didn't quite get it right, they decided to meet again in Philadelphia.
Right.
Okay, Doug, just thanks a lot for doing this today. We're going to try to get back on Friday, I think, to do the next part of it. But can you tell everyone where to find you in the meantime?
DouglasVGibbs.com, DouglasVGibbs.com. And if you are right there at the beginning of December, when you watch this 2024, I've been such a bad boy. We've been doing these videos. I have not been putting them on my site. So I started putting them on my site. If you can find the origins of the Bill of Rights at DouglasVGibbs.com, where my blog is, Political Pistachio, right now, if you're watching this close to the beginning of the month. I'll be continuing to put these videos on my website, as well as you can come here. Just look for the Re-Federalist Report at rumble.com/warhamster. As for me, I not only have the website, I am on the radio on 3 radio stations in Southern California. Constitution Radio on Saturdays from 1 to 3 Pacific, KMET 1490 AM. And I have the Mr. Constitution Hour on KCBQ, The Answer San Diego, and KPRZ, the Christian station in San Diego. Or you can just go to any podcast platform and just type in Mr. Constitution Hour by Douglas V. Gibbs. I will probably be there. As for what I do, in addition to classes on Tuesdays with my friend Ron, MrConstitution.com, put a hyphen between the Mr. and the Constitution. And of course, I have a number of books I've written. Always go to DouglasVGibbs.com if ever you have a doubt. And if you want to help fund what I do, because advertising pays for 2/3 of what I do. The other third comes out of Doug's wallet. So hit the join button link there on my website, DouglasVGibbs.com, $9 a month, become a patron, or on the main page, go all the way to the bottom, hit the donate button. We're always needing funding just to keep this thing rolling. We got big plans, talking to legislators around the country. I've even applied for a Constitution czar with the Donald Trump administration. We'll see what happens on that.
Well, you're going to need a staff.
Exactly. They contact me. I know exactly who to call first. Or hamster.
Yeah, it's funny you say that, because I've actually put in my resume to the DOGE, and
really?
Yeah. I have a friend who worked on RFK's campaign, and he agreed to pass it along. He's met Vivek and Elon, and he's passed my resume along. I have not heard back from them yet, but I've got the permission of the lady hamster that if I get the call, we can go. So
all right, and once again, as you did with me, you do need a staff.
Absolutely. Hey, everybody! Also, you're going to want to check out tomorrow on the Colonel's Corner with Colonel Connor Watkins. I'll be every Thursday at noon Eastern. I'm going to be most Thursdays, actually. I'll be doing an ongoing series with her. Tomorrow, I think we're going to start on Skull and Bones and secret societies, and that's going to be something you really want to tune into. And I'll have it up on my channel as part of my Shadow State series.
You're ruining some of my opinions about some of my favorite economists. Thank you.
Isn't that my job? All right, cheers, everybody. See you next time.